Good morning and welcome to this series 2 on audit, control, governance, risk, and compliance. As part of series 2, today we are going to touch base on the European Union Artificial Intelligence Act. It's an attempt to cover the subject. The intention is to go through each topic, try to understand the spirit behind what has been put up as an act. Any student of risk management, audit, governance, compliance team, general management, a good view about what is this act trying to achieve. Let's start the journey. Morning and welcome back. This is Savit Vittal Salian. We are going to cover the European Union Artificial Intelligence Act. We'll go through section by section. So let's start. Artificial intelligence has rapidly evolved, becoming integral to various sectors such as healthcare, finance, transportation, and more. While AI offers numerous benefits, it also poses significant risk, including ethical concerns, privacy issues, and potential biases. Recognizing the need for a structured regulatory framework, the European Union introduced the Artificial Intelligence Act to ensure the safe and ethical development and deployment of AI technologies. This session is an attempt to provide an analysis of the AI Act, exploring its background, key provisions, risk classifications, governance structure, enforcement mechanism, and its potential global impact. Do note the important part here is the Act was introduced to ensure safe and ethical development and deployment. Let's look at the background now and its legislative journey. The journey towards the AI Act began with the European Commission's paper known as White Paper on Artificial Intelligence, a European approach to excellence and trust. Do take this word specifically, the European approach. We'll come to this later, but it is something which is very specific. It was published in February of 2020. This document outlined the EU's vision for AI, emphasizing the importance of balancing innovation with fundamental rights and safety. You note it's the EU's vision. Subsequent debates among EU leaders culminated in the official proposal of the AI Act by the European Commission on April 21st, 2021. After extensive negotiation, the European Parliament adopted the Act on March 13, 2024, followed by a unanimous approval by the EU Council on May 21st, 2024. The Act entered into force on 1st of August 2024 with its provisions set to become applicable over a phased timeline. Let's now look at the triggers for creating this EU AI Act. The EU Artificial Intelligence Act was driven by a combination of technological, societal, legal, and ethical triggers, alongside several high profile incidents that exposed the risk of unregulated AI. These triggers highlighted the need for a harmonized framework to ensure AI systems are trustworthy, transparent, and aligned with EU values. The first one is from a growing use of AI in high stake context. What are high stakes? AI was increasingly being used, or in fact, it is used in critical sectors such as healthcare, law enforcement, recruitment, and public services without a legal framework to regulate potential harm. We will go into this detail as we move forward. At this point of time, it is more important to understand the trigger point at the top. The second is ethical and human right concerns. As AI started to go deeper into the lives of every human in critical areas, the ethical and human right concerns started to grow, wherein post observation it was identified there were issues with algorithmic bias and discrimination. We really did not understand how it works. Effectively, transparency was missing, what we call in technology as a black box. AI, loss of human agency. We'll come to this with examples as we move forward. And of course, invasion of privacy via biometric surveillance. It's an example, but privacy was a major concern here. The next was regulatory fragmentation risk. What was observed as AI started going deeper into our societies, use of AI, every member state in EU started introducing their own national AI policies. Now, what was observed was this was creating the risk of a fragmented internal market. The EU wanted a harmonized single digital market approach. This was trigger 3. Trigger 4 was the EU aimed to position itself as a global leader in trustworthy AI, differentiating its approach from other countries, some of the countries which are state driven model or innovation first model. It did have its concerns on the fundamental rights. So EU wanted to position itself as something which can be trustworthy, taking care of the fundamental rights of its citizens. They wanted to differentiate itself. The next trigger was the policymaker recognized that trust is prerequisite for widespread AI adoption. The AI Act was designed to enhance confidence in AI, especially in public service and justice system. So from the point 4 and point 5 perspective, it is all about trust and linked to business economies, and it's about the optics, that here is a place where there is a policy, there is a process, there is a rule of the land which protects the fundamental rights when it comes to AI. Do understand this, why it is critical. Point 3, 4, and 5. The wisdom in the European Union gave them a perspective that AI is the future. Hence, it will all boil down to how trustworthy a business would be when it has AI in it delivery. So if you look in future, it will potentially play down as, is this product, is this AI technology and product from Europe? If so, then it is of a better quality, something which can be relied on, and hence in future when an AI product and technology is there in the market and it has a EU stamp, it would be preferred over others. So hence EU had the wisdom and the foresight for taking a stance on how their AI would be. So this law is towards that. It's one perspective of how business planning can be done using an act to provide a perspective, to provide an optics which will be used or potentially be used in future for commerce. This is food for thought. Let's look at a case study to have a better perspective. The Dutch government implemented SIRI, which is a short form for System Risk Indication. It was an AI based predictive system to identify citizens at risk of committing welfare fraud. The system aggregated data from multiple sources, which included employment data, housing data, tax data, etc., to generate the risk profile. In this, the problem that was identified was first, lack of transparency. Citizens did not know how risk scores were generated in the first place. So, while it was understood it came from sources from employment, housing, taxes, those are the sources from where this information came in. But the scoring system was not understood and, in a way, not explainable by the people who designed it. There were concerns of discrimination. Siri disproportionately targeted people from a certain income group, and migrant backgrounds were targeted. That is how the perception was and observations. It was also noticed that there was no mechanism to challenge the outcome of this system by the people who were affected, and no mechanism for a recourse. This went on for a legal path, and on February 2020, a Dutch court ruled that Siri violated Article 8 of the European Convention on Human Rights, which protected the right to privacy. The court cited the lack of transparency and potential for discrimination. The Siri case became a symbolic and practical example of why AI needs to be transparent, explainable, and aligned with fundamental rights. It was referenced in the EU parliamentary debates as a key reason to regulate high risk AI systems used in public decision making. Do note what we have taken is a single case. There are quite a few which helped EU to decide on the act. What I have shown you is an example, but it touches many aspects of the problem that was identified. Let's look at few more cases. The first use case is of AI being used to predict reoffending in courts. What was observed is it showed bias against defendants of certain color. This reinforced EU's concern about AI in law enforcement. The second one was trial using real time facial recognition raised alarms about the surveillance state. This specific led to calls for stricter control on biometric identification. It is related to the privacy aspect of it. The next one is using AI for hiring. What was observed was the tool was again biased for certain gender, and this was noticed, and gender bias in the higher system is something which is not acceptable. This influenced big time into the EU Act on AI. The last one is the misuse of personal data to manipulate political opinions. This was big time in news, and this strengthened EU's resolve to align AI with GDPR and privacy protection. Let's look at the objective of the AI Act. The primary aim of the AI Act is to establish a harmonized legal framework for AI within the EU, ensuring that AI systems are safe, respect fundamental rights, and promote trust among users. It classifies AI systems by risk level, namely unacceptable, high, limited, minimal. These are four categories. Some names have been interchanged, or there are alternative words being used. These we'll go through it as we move forward. By categorizing AI system based on the risk levels, the Act seeks to implement proportionate regulation that mitigate potential harms while fostering innovation. Additionally, the Act aspires to position Europe as a global leader in trustworthy AI by setting standards that could influence international norms. Do note in this, by classifying the AI system into four categories, the flexibility that you try to do in their act is differentiate what aspect would have what level of governance or control or checks and balances. On one hand, the ones which are the most sensitive would be subjected to higher level of visibility, governance, control, rigor. Whereas on the other extreme side, wherein they would also like to ensure that there are innovations which would require bigger leverage, flexibility, so that development, innovation in AI continues. You can't have a same level of control and governance, checks and balances as you have for sensitive aspect to the innovation side of it, because then you would stifle innovation. Hence, the European Union AI Act has maturely segregated into different levels. That's the spirit of why there is categories here. What's the scope and applicability of the Act? The AI Act applies to all AI systems placed on the market or put into service or used within EU, regardless of whether their providers are established within the union. However, certain exemptions exist, notably for AI systems developed or used exclusively for military, defense, or national security purpose. This broad scope ensures that a wide array of AI applications falls under the Act's purview, promoting a comprehensive approach to AI regulations. Now, if you look at it again, all systems placed on the market or put in service, regardless of the provider's location, which means if a system is being used by EU, within the EU, by any residents of EU or any process business, this act applies to them. Even if the head office of that AI development team or the organization is outside of EU, since the product is being used within EU by an entity, individual or organization, the act is applicable. We have to be very clear of it. So if you are a developer of an AI application and if an individual in Europe is using it, this act would be applicable for you. So this is how you can see this interpretation or understand this interpretation. Do note, even if you are not a developer, but an organization who has implemented AI in your process as a system or to provide services, the organization is outside Europe but has its presence in Europe. You have a location, or there are customers, or there are support vendors who are using this application or tool on your behalf to cater a client in Europe. This act would be applicable. So it is just not the developer, but the organization which is using the product to cater to a client in Europe, directly or indirectly. Now, coming to the key objectives and features. The AI Act categorizes AI system into four risk levels. This is something which we looked at earlier, namely the unacceptable, the high, the limited, and the minimal categories. AI system posing unacceptable risks such as social scoring by government are banned. That's the unacceptable risk. We'll go into examples as we move so that it becomes clearer. But this is how the top looks like. High risk AI systems, like those used in critical areas like healthcare, recruitment, must comply with strict requirements, including risk mitigation, data quality, and transparency. Again, we will go through a few examples so we really understand this space. Systems like chatbot must clearly inform users that they are interacting with a machine, and certain AI generated content must be labeled. This is the transparency aspect of it. Then we have something called as GPAM, which is general purpose AI model. The Act introduces specific rules for the development and deployment of general purpose AI model. From an innovation support perspective, the AI Act aims to foster innovation, particularly for small businesses and startup. The Act includes provisions for market monitoring, market surveillance, governance, and enforcement. Non-compliance with EU AI Act can result in penalties ranging from 7.5 million euros to 35 million euros, or 1.5% to 7% of the worldwide annual turnover, depending on the type of the non-compliance. Do note, this one section is a major reason why this act would require a complete focus and attention from every organization dealing with Europe through their AIs or using AIs. The highest here is the 7% of the annual worldwide turnover. So you might have a very small presence in EU, maybe 1%. 99% of your revenue comes from outside of Europe. But if there is a breach, it could take about 7% of your annual turnover. Think through about it. Think through the sensitivity that EU has assigned to this act. It's, if you put it this way, that this is a good enough motivation for implementing this act in your planning strategies so that you don't end up into this extreme end of the penalty. The AI Act entered into force on 1st of August 2024, with provisions coming into operations gradually over the next 36 months or so, which means if you when you are looking at this video, it's already in play. Some sections are already in force. Now you should look at how much of it is Euro focused, what is the level of compliance you have in play, what is required. So the penalty aspect will bring into focus the priority part of it. You would need to ensure priority in your planning, strategy, action, deliveries when it comes to AI implementation in EU. Let's look at the top impact and significance. The European Union AI Act is considered the world's first comprehensive regulation on AI. Here it is important that it's comprehensive. While there are many AI Act in play, but the real comprehensive one is considered to be the European Union AI Act. It is setting a global standard for AI governance and ethical development. The AI Act aims to ensure that AI systems in European Union are safe, transparent, traceable, non-discriminatory, and environmentally friendly. The AI Act emphasizes a human-centric approach to AI development, prioritizing safety, fundamental rights, and ethical considerations. Good morning. We have reached the end of part 1. At this point of time, I think you would have understood the basics of the European Union Artificial Intelligence Act. We have understood why it was required, what were the trigger points, and a top view on certain key aspects. With this, we'll conclude this part 1 and we will go for part 2. Before doing that, for some of the audiences, I had got queries about, is this applicable for only EU? What about other countries? The answer is, take this as a benchmark. There are individual countries AI Act, but since this has matured itself, most of the regulators do engage with each other, share their best practices. Hence, the principles of AI Act would be similar. There might be changes specific to the country. Example, the penalties. Here it is euro, in other countries it would be dollars, or it could be rupees if it is in India. Again, the penalty would also differ. Here is at 7% of the gross globally. It could be 5%, it could be 8%, 10%, 15%. It depends on the country. So with that minor changes, the rest of the principles look sound. Hence, I assume at this point of time that if there is an AI Act anywhere globally, there would be a reference to the EU Act. Of course, there would be maturity with any new act coming in this space, because it would evolve. What you should also expect is the EU also going through revisions, because best practices are learned two ways. So at this stage, the EU AI Act is in the forefront, but don't be surprised if maturity in other part of the geographies catch up and then exceed. But this is a good start. Now the question comes is, for anyone who is in this space, expected to know about the EU Act, how do you go about managing it? If your organization or your services are based out of EU, there is no two way about it. Take a copy of the EU Act, go through it, map it to your processes, and work on it, so you don't end up having a negative impact. But if you are in doubt, you're not based in EU, you have some presence in EU, or you have business or partners, how that should be addressed would be a query of many of the risk managers, auditors, general management, senior management, board. In such a case, I would recommend, but then you take a call, do a pre-audit on the scope. Look at your assets, look at your services. Check out whether you cater to Europe in any form and shape. Now go with a thumb rule that if your operations or the business heads are not sure, then go with it that this is applicable. That's a better way rather than saying I'm not sure, hence I don't think so it is applicable. No, don't go that way, because if it is applicable but you have taken it off the books, then you would be caught off guard. In order to avoid it, every time you hear I don't know, make it a bucket point that this is in scope, unless otherwise proven to be no, it is not. Till the time it is an explicit no, consider it that you are in scope or your business is in scope. Hence, I highly recommend, do an audit to understand the scope. If you have resources, teams who can do it, well and good. If not, take help of consultants and ask them to do that for you. This helps you because it would be a very short audit, because it is to first understand the scope, and then you can look at the plan of action on that scope. So that's a recommended one. Having said that, you have your own strategies. Since this act was supposed to come, was visible to most of the organization, I'm sure you would have already done it, but those organizations who are yet to catch up, The fastest way is to do a scope audit, and then you can start from that point designing and planning your work. So, my best wishes for all the teams here. Let's conclude this part 1 and move to part 2. Thank you very much. Namaste.